good afternoon to all the viewers of KCGC TV. Myself, Anita Sharma, Assistant Professor, Khalsa College of Law. Today's topic is advantages of ADR over the formal court reforms. Now, ADR, that is Alternative Disputes Resolution. It means that disputed persons or any person who have any kind of litigation problems, they can solve their cases out of the court with the help of an expert person who is a nuclear person, and he can solve their cases with the coordination, cooperative, and in a proper communication way, so that it is easy to solve your cases out of the gate, because most of the people, they are afraid of going to the courts, and they are afraid of the complicated procedure of the courts, let it be civil cases or criminal cases, etc. So this is one of the best forms, that is the alternative dispute resolution. It can solve the cases with the help of a third party who can assist the disputed persons in a way that they can solve their cases in a quick, in a less time consuming forms. And so there are many advantages of going to the ADR. Forming of the ADR, that is alternative dispute resolutions. First and the foremost thing is that alternative disputes resolution has less formalities, and not more complicated formalities are not included. Like if you go to the courts, you have many complicated formalities. They will follow CRPC or Civil Procedure Code, and more of the formalities are involved if a person goes to the court. But with the help of the ADR system, it's very nice to solve your problems, etc., with the help of a nuclear person outside the court. You need not have to go to the courts, and it can be solved in a better way. Also, under the ADR system, the doctrine of equity is adopted. It means that equal justice is given to the disputants. Both the parties are to be heard in a proper way, and their solution can be made on the spot. Equity means that both the parties are benefited with the help of the decisions which are given by the ADR, that is the alternative dispute resolution. It can be in the way of mediation or negotiation or any other way. And first and the foremost thing is that under the ADR system, direct participation of the disputants are there. If a person solves their problems or the dispute with the help of the ADR system, then first and the foremost thing is that direct participation. It means that the disputed parties have a direct communication with the party who resolves the disputes, that is the ADR person, the nuclear person or mediator or negotiator, let it be arbitrator, etc. They can solve their cases in a better way, and in a direct participation is there. Because if you go to the courts, the lawyers or the judges will not see to it. You will have to represent your case with the help of an advocate, and all the things is that there is sometimes miscommunication between the advocates and the client, etc. Then then you can have some also other ways that direct participation is there, and moreover communication between the parties is also there. Communication between the parties, this is very effective form in the ADR system, because if we go to the courts, there is no direct participation of the or direct communication between the parties, because both the parties are opposite to one and the other, and you cannot have any kind of communication between both the parties. But through the ADR system, it's better that you can have a direct communication with both so that we are able to solve. The ADR system is able to solve the cases in an effective manner, and it is beneficial basically to both the parties. So let us come to, there are many different kinds of the ADR system which are adopted in India. That is negotiation, mediation, arbitration, then conciliation, Lok Adalat, and as well as Panchayat. Coming to the negotiation, negotiation is a form of ADR system in which the parties have a direct contact with each other, and a negotiator, with the help of the negotiation, you can solve the disputes in a better way, that is, which is beneficial to both the parties. Then coming to mediation is one of the very best form of the ADR system. With the help of the mediation, you can solve the cases, let it be family disputes or it can be any kind of dispute relating to the civil disputes. Mediation is one of the most important form of the ADR system, and it is beneficial to all the members or the disputed parties also. With the help of the mediations, most of the courts also suggest that in case of family matters, that you can go to the mediation centers and it can be solved in a better way, because with the help of the mediation, family matters are very much sensitive matters and it can be solved in a better way by going to the mediation centers. Even in the civil courts or the district courts also, a mediation center is set up in the courts, so that in case the judges thinks that if any case require any kind of mediation, then he can send that case to the mediation center. So it is a very better way. Then coming to the arbitration also, with the change of the commercial activities, etc., and the trade, with the inter-trade commerce, etc., in India, arbitration is one of the most important way in which, in case of the business deals, business organizations, you can solve your case through the arbitrators. It means that under arbitration, if parties are living abroad also, and if both one party is living in India, you can go through you can have an arbitration agreement, so that in case of any kind of dispute, if it arises in the future, you can go and seek the help of the arbitrator, and an arbitrator can solve your problem, that is the business terms, in a better way. And then coming to the Lok Adalats. Lok Adalats is playing a very vital role today in India, because through the Lok Adalat, many of the cases are being solved in a better way, in an effective way, and the most of the time is, otherwise most of the time taking decisions are taken by the courts. So Lok Adalats is a form of the area system in which quick decisions can be made and in a better way. Then there are different forms of, you can say panchayat is also a form of area system. Under the panchayat, because panchayat in a rural area, people living in the rural area, they cannot afford to come to the cities and solve their disputes. For them, panchayat is there. They can solve their petty disputes through their panchayat, and it is equally binding on them. Then coming to the basic advantages of the area system. Now, alternative disputes resolution, it supports the court reform. ADR is one of the system in which that most of the, if you want any kind of changes in any kind of form or some technical issue is involved, then it can be solved with the help of an ADR system or a nuclear person or an expert person coming to, if any kind of technicality is involved also, then it can support. ADR system is such that it supports the court reforms and it also supplements the courts. It means that where there is a workload, then in the courts, in our courts, we are seeing that in civil courts or criminal courts, might be district courts, high courts or Supreme Court also, there are a lot of pending cases in them. For them to solve them, ADR system can help as a supplement. You can take the help of the ADR system and solve the cases in a better way. Now coming to, first of the thing is, under the ADR system, there is the increased satisfaction of the disputant, because if you go to the civil court or the criminal court or any kind of courts, one of the party will be a winning party and the other party will be a losing party. It means that in any case, one party will be winning and the other party will be losing the case. But under the ADR system, it's made in such a way that both the parties have the maximum satisfaction, because both the parties are satisfied. They have an effective and efficient decisions are made with the help of the ADR system, with the help of the expert persons. So it is better because it deals with expert persons, expert nuclear third party who is not involved, who does not have any kind of bias under them. So it is a better way. And more or than that the decisions the justice can be given to the disadvantaged persons, the people who are poor, who cannot afford the litigation charges or can hire the advocates. They can go to the area system and take the relief. In any case, it can be most of the cases civil cases or matrimonial cases, etc. This is one of the way that most disadvantaged persons who does not have the money to afford or to give the hectic fees of the advocates, then also they can have a proper way to solve with the help of the area system. Now coming, one of the most advantages of the area system is that it is less expensive. If we compare it with the natural formal court system, then it is less expensive, because under the courts, if you go for any kind of civil court or criminal cases, etc., hectic fees is charged by the advocates, and most of the people, they are not in a situation to file the such of the fees, etc. But with the help of the area system, it's less expensive, less cost consuming, and effective results are given with the help of the area system. Okay, and first one more advantage is that it takes less time, because we have seen that in the civil or the criminal cases or might be matrimonial cases, it takes a lot time to solve any kind of cases. But with the help of a area system, it takes less time period, and it can be solved in an efficient and effective manner, less time consuming as it, and your decisions can be supportive and satisfactory, with the disputants can be satisfied with the decisions taken by the area system. Now, why the need of area system is there? First of the thing is, there are many reasons. In the present scenario of our Indian system, it is necessary that you should have some area system, and with the change of the time, with the globalization, with the modernization, with the intertrade, commerce, etc., it is necessary, and most of the requirement need of the hour is that we should have the area system over the formal court system. It should be supplement to the court system, so that new innovations or any kind of technicalities is involved, then also it can be solved with the help of the area system. Now, first of the four, because there are many of the pending cases, areas of pending cases are there in the civil and the criminal courts. You can say Allahabad court, which is the biggest high court in the India. Most of the pending cases are lying in the Allahabad courts. Therefore, and most of the judges, because there is a lack of infrastructure also, because of the lack of infrastructure of the courts, the formalities involved, and all the formalities, they can switch on to the area system. There is also some sluggish government machinery, that is infrastructure of the courts are not good. Then there can be vacancies are there of the judges, also sluggish, and most of the lay persons, they are not able to understand the procedure or the formalities which are involved under the court system. So it is better to shift on to the area system. And moreover, you can see that there is, if you go on for the court procedure, there is the concentration of the litigation in the hands of some of the advocates only. And if you go to the area system, you can shift on to, you can solve your case in a better way, in a less expenses, then cost is come less, and you can have a proper, efficient and effective decision. Now, the need of the hour is to shift on to the area system, so that all the disputants can have justice in a proper and effective manner. Thank you so much.